Picture this. It's 3 in the morning. You're having a perfectly pleasant dream about organizing your Tupperware drawer. Suddenly, bam, your front door is where your wall used to be. Bright lights are in your eyes. Very shouty people in tactical vests, muddy boots redecorating your living room. Before you can ask about the lid, you're in handcuffs. Then comes the line delivered with theatrical flair. You have the right to remain silent. It's a moment so ingrained, it's practically a cliché. We've seen it in movies and TV shows. Right after the car chase, just before the commercial break. But do you actually understand what that means? I mean, really understand it. The Miranda warning is profoundly misunderstood, right up there with how Wi-Fi works, and why anyone would willingly eat kale. We nod along when the TV cop recites the lines. The silence part is just the beginning. To understand why these rights exist, we need to take a little trip back in time. No, not to see the dinosaurs. We're going to 1963 to Phoenix, Arizona. This is where we meet a man named Ernesto Miranda. Ernesto was arrested for a terrible crime. After a 2-hour interrogation, he signed a written confession. He was convicted and sent to prison. Case closed? Not quite. The crucial part isn't the crime, it's the 2-hour interrogation. He had no lawyer present. He was never told he had the right to one. His appeal went all the way to the Supreme Court, Miranda v. Arizona. The argument, a confession squeezed out under immense psychological pressure, is worthless. Imagine a small windowless room. You're alone, you're scared. Trained professionals use every trick to get you to talk. They can lie to you. The court saw that power imbalance as a massive problem for justice. The Supreme Court, in a 5-4 decision, decided something had to change. They didn't ban questioning. They said, if someone is in custody, police must level the playing field a bit. Make sure the person understands they're not powerless. The Miranda warning is a verbal shield for the Fifth Amendment right against self-incrimination. Alright, let's dissect this famous legal script line by line, because the details here are everything. First up, the big one. You have the right to remain silent. This is the foundation of the whole thing. It means you do not have to answer any questions. Not about where you were last night, not about your favorite color, not even about whether you think that officer's mustache is a bold choice or a cry for help. You can, and should, just shut up. This right comes directly from the Fifth Amendment, which protects you from being a witness against yourself. Next, we have the scary follow-up. Anything you say can and will be used against you in a court of law. It's the legal equivalent of a hot mic that is always on. Every word you utter, from a full confession to a seemingly innocent comment like, "I wasn't even on that side of town," can be twisted, analyzed, and presented to a jury. Maybe you were on that side of town but had nothing to do with the crime. Too late! Now you look like a liar. Then comes the cavalry. You have the right to an attorney. This is your lifeline. This is the part where you get to call in a professional who actually understands the ridiculously complex rules of the game you've been forced to play. If you cannot afford an attorney, one will be appointed for you. It democratizes the right to counsel. These 4 parts together form a powerful shield, but only if you understand what each one means, and, critically, how to use them. Now we venture into the fog of legal myths, a place where common sense goes to die. The biggest, most dangerous myth is that staying silent makes you look guilty. Let's be crystal clear. It does not. The Supreme Court has explicitly stated that your silence cannot be used as evidence of guilt in court. A prosecutor can't stand up and say, "Ladies and gentlemen, he refused to answer questions, so he must be the one who stole all those garden gnomes." Your silence is legally neutral. It's you exercising a constitutional right. Another common misconception is that if the police don't read you your rights, your case gets thrown out instantly. In reality, it's not that simple. If police fail to read you your Miranda rights, it doesn't invalidate the arrest itself. What it does mean is that any statement you made during a custodial interrogation can be suppressed, meaning the prosecution can't use it as evidence. But if they have other evidence like fingerprints, witness testimony, or the stolen garden gnomes in your trunk, your case can absolutely move forward. The lack of a Miranda warning only poisons the confession, not the entire investigation. Many people think that just being quiet is enough. It is not. The courts have ruled that you must unambiguously invoke your right to silence. Just sitting there quietly might be interpreted as you thinking about your answer, not as you refusing to answer at all. You have to be clear, saying something like, "I want to remain silent. I am exercising my right to remain silent." The same goes for a lawyer. Saying, "Maybe I should talk to a lawyer," is legally useless. You have to be direct and firm. "I want a lawyer." Finally, there's the myth that Miranda rights apply every time you talk to a police officer. This is fundamentally untrue. An officer can walk up to you on the street and ask questions, you can answer them, and those answers can absolutely be used against you all without a Miranda warning, because you weren't in custody. For your Miranda rights to actually apply, two specific conditions must be met simultaneously. It's like a terrible legal recipe. You need 1 part custody and 1 part interrogation. First, custody. This doesn't just mean you're in handcuffs in the back of a squad car. Would a reasonable person in your situation feel free to terminate the encounter and leave? If the answer is no, you are likely in custody. Or your own home with 2 officers blocking the only exit. Now, interrogation, it's broader than you'd think. Not just direct questions, any words or actions reasonably likely to elicit an incriminating response. Psychological ploys and subtle tricks count. Officer might not ask directly, they might sigh or whisper to a partner, designed to make you talk. You need both. In custody but not interrogated, you blurt, "I did it." Admissible. Voluntary confession, not the product of interrogation. Officer questions you on a street corner but you can walk away. Not custody, Miranda doesn't apply. The statements you make can be used against you. Only when custody and interrogation combine must police read rights. Know this 2-part test so you know when your protections kick in. Custody means a reasonable person wouldn't feel free to leave. Interrogation means anything likely to elicit an incriminating response. Both together. Miranda applies. Okay, you've been arrested. The adrenaline is pumping. Be clear, be calm, be firm. The 2 magic phrases. Officer, I am going to remain silent. I want a lawyer. Say them out loud. Practice in the mirror if you have to. These sentences are powerful, like pulling the emergency brake. After you say them, stop talking, completely and utterly silent. The police are trained to get you to re-engage. They might make small talk about your family or the weather. This is a trap. Even "I don't need any help" can waive your rights. Your silence must be absolute. Your lawyer will do the talking for you later. In Burguis v. Tompkins, he was read his rights and stayed mostly silent for hours. He never said, "I want to remain silent." An officer asked if he prayed, he said, "Yes." That yes helped convict him. The Supreme Court said he hadn't unambiguously invoked silence, so the playbook is simple. First, clearly state you're remaining silent and want a lawyer. Second, say nothing else, nothing, nada, zip. Be a polite but uncooperative statue. Don't sign forms without your lawyer, don't agree to searches, don't try to explain your side of the story. Repeat, I've invoked my right to a lawyer, and I will not be answering any questions. Be a broken record. It might feel awkward, but temporary awkwardness now beats a permanent criminal record. Ultimately, your Miranda rights are not a magic spell that protects you automatically. They are a tool, and like any tool, they are useless if left in the toolbox. The entire system is built on the assumption that you know what your rights are, and that you will have the courage and clarity of mind to invoke them when it matters most. This is a huge and frankly somewhat unfair burden to place on someone in one of the most stressful moments of their life. Your freedom might literally depend on your ability to remember 2 simple sentences, and then have the fortitude to remain silent. We've seen countless cases where this knowledge made all the difference. People who understood their rights asked for a lawyer and stayed silent, and were able to navigate the system with a crucial layer of protection. Their lawyers were able to challenge evidence, negotiate pleas, or even get charges dropped. On the flip side, the stories of those who didn't know their rights are tragic. People who thought they could talk their way out of trouble often ended up providing the very evidence that was used to convict them. Their words, intended to prove their innocence, were twisted into proof of their guilt. This is not an abstract legal debate. This is about your personal liberty. It's about ensuring that a moment of panic, confusion, or intimidation does not end up defining the rest of your life. The police have a job to do. Your goal is to protect yourself. The most powerful tool you have is the shield granted to you by the Constitution, crystallized in that Miranda warning. So please remember this. The right to remain silent is not a suggestion. The right to an attorney is not an admission of guilt. Know them, understand them, and if the worst day of your life ever arrives, use them. Say, I want a lawyer, remain silent, and embrace the profound power of silence. Knowledge is power. Protect your freedom.